Hello and welcome to Chapter 5. So this week we are going to be learning about professional liability. So let's go over some basic definitions. Liability. All competent adults are liable or legally responsible for the actions on the job and in their private life. So liability is just your legal responsibility. Laws of agency. Law governing relationship between principal and agent. So what is an agent? One who acts for another person, and the law of agency may be expressed or implied. Next we have respondeat superior. This essentially breaks down to, in English, let the master answer. It kind of goes along with the physician is being held responsible for any acts that their employers do underneath of them. So like in a dental scenario, the dentist is the respondeat superior to his assistants and EFTAs as well. So for a lawsuit to succeed under respondeat superior, the injured plaintiff must prove three things. Number one, the injury occurred while the employee was working for the employer. They weren't like on their way home from work, or they weren't at home. They were actually like on the clock working. The injury was caused by something the employee would ordinarily do while working for the employer. And then the employer benefited in some way, no matter if it's small or indirect, as long as the employer benefited from it while the employee got the injury, then they can file this type of lawsuit against the physician or dentist, whoever is in charge of them. Employers have general liability for grounds and buildings, so they need to make sure that the grounds are kept up, like there's no big gaps in the sidewalk, or I guess like down trees, grass is kept neat, also protection from theft, fire, burglary. There's insurance on the building, that way if something does happen, the insurance can help cover that. Automobiles. So anytime automobiles are used for work purposes, which really isn't going to be in dental too much, the employer must make sure there's adequate insurance on the vehicles. Employee safety. So we must be working in a safe work environment. This one really does apply to dental because we're around a lot of hazardous chemicals, we're around a lot of sharp objects, so we need to make sure that our employer is providing us a safe environment to work in. Standard of care and duty of care. So standard of care is the level of performance expected of healthcare workers carrying out their duties. Just kind of the standards that we should do our work by, what we believe is fully expected of our job title. And then duty of care are obligations of health workers to patients or non-patients, such as family members or former patients. Reasonable person standard. So the standard of behavior that judges a person's actions in a situation according to what a reasonable person would or would not do under similar circumstances. We are responsible for our actions or our failure to act under the reasonable person standard. We can be charged with negligence if someone is injured because we failed to perform an act that a reasonable person in similar circumstances would perform. My mind always goes to like CPR circumstances, that a reasonable person would perform CPR if they see someone in cardiac arrest. And if you have your CPR certification and you have a patient who is in cardiac arrest and you do not perform CPR, then you could be charged with negligence because a reasonable person would perform the CPR. Guidelines for healthcare practitioners. So we must practice within our scope of training. We shouldn't be performing dentist duties or hygienist duties that are outside of our EFTA scope. We should use our professional title. That goes with our education and experience. Maintain confidentiality, especially to our patients. Prepare and maintain health records accurately. Document accurately. Use appropriate ethical and legal guidelines for patient information. Follow employers' established policies. Follow appropriate legal guidelines. Maintain and dispose of controlled substances, which in dental we don't have access to that necessarily. It's more so the doctor is filling out those prescriptions, so that doesn't necessarily apply, but in like a hospital setting, that would apply to healthcare practitioners. Follow risk management protocols, meet requirements for credentialing. So we need to make sure that we are keeping up with our licensure, doing RCE credits every 2 years, keeping up with CPR, child abuse mandated training, all of that. And then help develop and maintain policies as well. Next, we'll talk about unintentional tort of negligence, which is any deviation from the accepted medical standard of care that causes injury to a patient. It is the basis for professional malpractice claims. It is also the most common liability in medicine. Professional liability claims. So first we have malfeasance, which is the performance of a totally wrongful and unlawful act. So it's just unacceptable, absolutely wrong, no matter which way you look at it. Then we have misfeasance, which is performance of a lawful act, but you perform it in an illegal or in an improper, inappropriate manner. And then nonfeasance is the failure to act when one should act. So there are 4 elements to prove negligence. Number 1, duty. The person charged owed a duty of care to the accuser. So especially like in a medical setting, the person who owed a duty is usually the physician or the dentist, someone higher up who is expected to give the patient care. Dereliction, so the healthcare provider breached the duty of care to the patient. 3, damage. Court-ordered monetary awards to patients given as a result of legally recognized injuries to patients. And direct cause, so the breach of duty of care to the patient caused an injury of some sort or some kind of issue for the patient. So we have about 5 different types of damage awards that people who are claiming these lawsuits can get. First, we have general compensatory, so that compensates for injuries or losses due to violation of a patient's rights. Then we have special compensatory, to compensate for losses not directly caused by the wrong. We have consequential, to compensate for losses caused indirectly by a product defect. Punitive is punishing the offender, so the dentist or doctor. And nominal, to recognize that rights of the patient were violated though no actual loss was proved. Doctrine of common knowledge. So res ipsa loquitur, the thing speaks for itself, which essentially breaks down to the negligence that occurred is pretty obvious. 3 conditions must occur for this. So the act must obviously be under the defendant's control. The patient must not have contributed to the act, and it must be apparent that the patient would not have been injured if reasonable care was used. Cases of res ipsa loquitur. So leaving foreign objects in a patient's body during surgery. I'm sure we've all seen or heard of this somewhere. Like in the picture there, a pair of surgical scissors were left in the patient's cavities. So this obviously is a very big issue. Like the hospital or whoever was performing the surgery should have been counting the instruments, making sure that they were all accounted for after the surgery. So this is obviously a big issue and lawsuit. Accidentally burning or injuring a patient while they are anesthetized. Damaging healthy tissue during surgery. Causing an infection by using unsterilized instruments. Wrongful death statutes. So state statutes that allow persons beneficiaries to collect for loss of the estate of the deceased for future earnings when a death is judged to have been due to negligence. So this allows, like say a patient died as a result of negligence, it allows their children or spouses to be able to kind of collect any money or awards due to them since their loved one is deceased. State may also prosecute a healthcare practitioner under criminal statutes for the wrongful death of a patient. Next, let's discuss the phases of a lawsuit. So first is the pleading phase, where a summons is issued. Then we have the interrogatory or pretrial discovery phase, where a subpoena or a deposition may occur. Then we have the trial phase. So this is where a jury is selected and witnesses are called to testify for both sides. The jury then reaches a verdict in the case. And then there's an appeals phase where they can request for the case to be reviewed by a higher court if they don't agree with the decision that was made. Types of witness testimony. So there is fact, where a witness provides fact that he or she has observed in the process. There's also expert witnesses, where people that are experts in the field are able to kind of give insight to what they would have done in this case and see if it aligns up with what actually happened. Alternative dispute resolution. So, techniques for resolving civil disputes without needing to ever go to court. The use of neutral mediators or arbitrators can be used, where you're not going in front of a judge, but you have someone whose job is a mediator to kind of let both parties speak and try to resolve the issue without needing to go in front of the judge. There's two types. So mediation is where a neutral third party listens to both sides and then helps resolve the dispute. The mediator does not have authority to impose a solution. They have to just kind of let both sides figure it out, and they help facilitate the conversations, but both parties have to come to the agreement, and if they don't, then it goes in front of the judge. And then there's also arbitration, where both sides have to agree to what is set by the arbitrator. The arbitrator has authority. Next, we have consent. So consent is permission from a person, whether expressed, where they're verbally agreeing or consenting, or implied, so where they're doing an action and not necessarily verbally saying I consent, but by, say, opening your mouth while the doctor is doing an exam is implied consent. You're opening and kind of agreeing to let the doctor do his job. So in healthcare, consent is permission to examine the patient, perform tests that aid diagnosis, and treat the patient. Next, we have the doctrine of informed consent, which is usually outlined in the state's medical practice acts. It includes proposed modes of treatment, why the treatment is necessary, risks involved in the proposed treatment, available alternative modes of treatment, and the risks that they may pose, and then risks involved if treatment is then refused. So there are certain people who cannot give informed consent. They include minors, so those under the age of 18, people who are mentally incompetent, which is usually determined by the court, not just them saying they're medically incompetent, and then people who speak limited or no English, who just can't understand what the consent is asking for them. There's also a few times when consent is unnecessary. So number one, in an emergency situation, and then number two is going to be when you are covered by the Good Samaritan Act. So, like I mentioned earlier about giving CPR, some people may have like a DNR and they don't want to be revived if something happens to them, but you may not know that as a passerby on the street if someone goes into cardiac arrest. And you get down there and you start doing CPR and you bring them back to life, and the patient sues you for bringing him back to life or breaking his ribs or something. Under the Good Samaritan Act, as long as you give care in good faith, act within your scope of training and knowledge, use due care under the circumstances, and do not bill for any services, they cannot sue you under this Good American Act. So as seen in this picture, if it's an emergency situation, you didn't cause the situation, and you are providing compassionate care, they cannot file a lawsuit against you for providing that care to them. Thanks, guys.